So you have rights and obligations. The other party also has rights and obligations. And an agreement is entered into. That becomes a contract. But apart from the number of parties we know as bilateral, we also have at times what we call the unilateral contracts. Very scarce, but we have also a unilateral contract. When we say unilateral, it means one-sided contract. One person is making an offer and the same side is accepting the offer. It should have been one side making offer and the other side doing the acceptance. Then in unilateral contract, it's a contract arising where an offer is made in the form of a promise to pay in return for the performance of an act, so that the performance of the act is taken to imply an asset. A special example is maybe police advertising for a suspect for a prize. Often it is published in the papers that a criminal or a suspect is on the run, and anybody who will identify such a suspect or a criminal will be paid an amount of money. For example, 10,000 cedis. Anybody who would identify that criminal, police can bring that and put it in the papers for everybody's hearing. So in such a case, the police is making the offer and making the acceptance, and when you find or identify the criminal, you are only given assent to the acceptance. So it means it's unilateral. So when you bring or identify the criminal, then they cannot give you the money exactly what has been promised or published. So it could be anybody at all. It's thrown to anybody who could identify, and the amount has to be paid. So if it were a normal bilateral contract or agreement between two people, there would have been a bargain. There would have been a bargain. I would have asked for 15,000 and not the 10,000 they suggested. And then the other side would have also said, it's too much, reduce it. Then he would have also come down to maybe 11. Then we can see that there is some bargain in the transaction. But a unilateral is absence of a bargain, and only the person making the offer or suggesting is the same person who has determined how much to pay you, and you only have to give assent to what he has decided. So we call this type of thing a unilateral contract, which also exists. And when we take the case of Khalil versus Carbolic Smoke Ball of 1893, this is a popular case in contract law. Khalil versus Carbolic Smoke Ball. Students are supposed to read this case. That's the principle of openness and to advertisement, that it is to the whole public and therefore nobody can accept it readily. That case established something different from the general perception of advertising to the whole world. I mean, it needs to be read. The one thing about unilateral contract is, I'll explain further, is that imagine somebody has not heard anything about the advertisement of 10,000 cedis to anybody who could identify a criminal. Imagine the person has identified the person who is the criminal, but did not hear or read anything about the promise of paying the 10,000, and later was reminded by a friend. The question is, can he go and collect the money? And if he wants to collect, could they refuse giving him the money? There are a lot of cases to confirm that the promisor is not obliged to give him the money because he has not made any conscious effort. He was not motivated by the announcement he has not seen. So if you read or hear about the promise of paying an amount for anybody who finds out something or who identifies the criminal, then he cannot be paid that amount. He cannot insist collecting that amount because he has not given in any conscious effort or is not being motivated by the announcement to demand a payment for the work he has done. At times you think it is unfair, but by the principle, you must have acted upon the promise. Not reminded there has been a promise, and you go back and demand for payment of the amounts promised in the papers or anywhere. That is the only explanation I want to give about that. You can read further, and a better understanding can be also resolved. Now we have contracts like multilateral contracts at the international level made up of several parties. We have multilateral, 2, 3, 4 countries can make a contract. Then at the international level, we can have universal contracts. The world community as a party, like international trade laws and all that, we have many parties. Now we can have another category of contracts, the common commercial contracts, non-negotiable contracts. Contracts are not only written, contracts can also be oral. Contracts could be just a documentation. They could be even employment letters issued. That can be a contract. Doesn't need negotiation. It could be sales invoices. Doesn't need negotiation. It's already prepared. And once you accept it, it's an agreement. Or purchase orders, or utility contracts, paying for electricity or water. These are all contracts which are not negotiable, but they are common commercial contracts, simple. They are all contracts. Then we have the complex contracts. They entail negotiation, or we can say negotiable contracts. They are more detailed contracts. They need serious negotiation. They need a legal framework and strict execution. They need strict execution, and that is where we even need the contract management skills. It is normally the complex contracts where the contract management is applicable meaningfully. So they need serious negotiations and how to monitor these agreements. Some of them are the construction projects, roads, dams, airports, stadia, all are complex contracts. Goods or services that are highly regulated are part of this category of negotiable contracts. Goods and services with detailed technical specifications, or international trade in goods and services. These are all complex contracts which need real negotiation or negotiating skills. Now, when we talk about the types of writing a contract, contracts are of two types. We have simple contracts, specialty contracts. The simple or the specialty contracts. Now, what do we mean by the simple contract? Simple contracts could be verbal, simple verbal, written, or inferred from an act of the contracting parties, an act of the contract. So it could be verbal, you call your friend and you call a witness. I'm selling my car to Mr. B. B has agreed on it after the description or the price, and there's a witness. You are making a contract. Or you could take a piece of paper and two people write their terms and obligations and rights. So it could be in a written form, or simple contract could be inferred from acts. An act of a person can also imply a contract. apart from oral speaking, talking, promising, or apart from writing, your action can also create a contract between two people. And how does it work? I can give an example. Where, for example, a taxi driver accepts a passenger by conduct, there are both an offer and acceptance to the passengers only, or may only speak of his destination. If you have a taxi driver and they put the destination on top of the taxi and you sit inside, the implication is that you have accepted to go wherever the taxi is going without speaking or writing. By your conduct, it is clear, it is established that you have agreed to enter and go to the destination you have seen before sitting in the taxi. Then the taxi has an obligation to take you to the last destination that he has seen before sitting in the taxi. I think it's a common practice we see in Ghana. When the taxi, if it's in Accra, they say Dansoman is going to Dansoman Estate, they put the board on top. This one is going to Nima, this one is going to Osu, they put all. If it's Kumasi, they say this is going to Kejetia, or the other one is going to Jisu. You can identify by what they have indicated on the taxi. So you don't need to talk. Once you sit inside, the indication or the implication is that you have agreed to be taken to the destination. So it's by conduct, not by oral, not by writing. So your conduct must be clear, convincing, which no reasonable person will doubt. Then we can say you imply an intention to enter into a contract with another person. So all this we can refer to them as very simple or simple contracts. When you see Section 11 of the Contract Act 1960 or Act 25, it provides that unless legislation requires, a contract need not be written. It is clear. A contract need not be written. It may be oral. So it means, therefore, that all contracts can be oral, except that a law has been made to exempt some types of contracts from being oral. So it means also that there are some contracts which cannot be oral. It will not be acceptable or enforceable in a court of law if you make it otherwise. So we have such laws or contracts which must never be made by oral, but only acceptable by form. So if you make a mistake, then your contract may be a good and a valid one, but may not be enforceable in the court because you have not followed the form. Especially contracts relating to financial transactions must be always writing. Conveyancing, buying of immovable property and conveyancing, currency transfer, mortgages, hire purchasing, all these rents, for example, renting somebody's house cannot be oral. If you will stay in somebody's house for more than 6 months, then it must be in writing. So oral will not, it's not wrong, but it will not be enforceable simply in the court of law because there is a form for it. You must follow that form in presenting your contract. So when you are making a contract, find out whether a law prohibits it from being oral or accept it to be oral. Then you must consult even the law that relates to that particular object of transaction. So the case of Hammond versus Enusen, 1974, Ghana law report, if you read that, there was an oral contract for the plaintiff to supervise repair works of the defendant's boat on the sea. The court upheld the oral contract. So although contract may be oral, it is advisable for it to be written because writing facilitates proof of contractual terms. So it is clear that in the event of a dispute, if the alleged contract is oral, the party relying on it has to prove its existence, to prove its contents or terms. So it is advisable that you reduce your oral engagements into a written agreement because of evidence and proof. Though the law may not be against that particular transaction, but it's advisable for evidence to make it a written agreement than oral, because oral can be very risky. Your witnesses may even die. One witness or two witnesses are not there, and the time the witnesses have a problem of consciousness to remember everything, that is another risk. And therefore, why not put your contracts or reduce them into a writing than keeping them oral? This is the idea behind it. So we continue with the second type of contract, the specialty. The special contract. No consideration is required for this type of contract, and it may be a deed, a writing, and always under a seal. You know what is a seal when you write a contract, like indenture for a land, a plot. You have an indenture with a seal, stamp. Is really sealed on the paper of the agreement with copies shared among the parties. So the beneficiary need not contribute anything in order to have any right in a specialty contract. It could be a transfer to another person. So even we have a customary transfer of property to another person where you may not need even a writing. It could be just what you give, and there is a witness to it, or you give a drink, we call it aseda, and is recognized as an agreement to that effect for giving property to another person. But in simple contract, there must be the element of consideration. There must be a consideration. Special contracts which do not require any consideration are very rare. For example, if Mr. Kwechi writes on a paper that he gives his house at Ejisu to Mr. Adongo, absolutely, he would be bound by it in the absence of a consideration. If that document is sealed and delivered to the promisee, the person who is going to be the beneficiary, Mr. Adongo. So delivery does not mean only physical delivery, it also means an act done by a party to show an intention to be bound. So it is clear Mr. Dongo does not, in this circumstance, provide any consideration, but he is entitled to the house voluntarily given to him by Mr. Kwachi. He has made a document, sealed it, and transferred to him. Can also be a specialty contract. But there is an evidence rule we call parole evidence rule. Parole evidence rule. So the rule states that, barring fraud, parties to a contract cannot lead oral evidence to contradict, vary, add to, or subtract from terms of their written contracts. You know, because of the existence of oral and written contracts, we always have a conflict of which one supersedes the other when there is a conflict between oral and written agreements. At times, the same parties will make part of their contract oral and part of it may be written, meaning they have started negotiations and discussions and reduce part of it into a writing, leaving the rest in the discussion or the oral form. So in time of conflict, one may be referring to the oral part and the other to the written part. Maybe they have agreed on the payment of maybe a price for goods in 3 installments, but on the paper they have mentioned only payment upfront or payment for only 2 times. So the other party, the principal is saying, cannot refer to the oral aspect which changes the price or vary the price or take away the price or anything. The court will not accept that. So you cannot use the oral part to contradict the written. That is in case of partly written and partly oral contracts. So that rule is very simple and straightforward. So a case example is Wilson versus Brobe, Ghana Law Report 1974, where the plaintiff, a retailer, sued the defendant to recover the value of goods. He credited the defendant. And the plaintiff tendered as an evidence an invoice signed by the defendant. So the defendant, illiterate, claimed that he was a guarantor for someone else and not a purchaser in his own right. That does not constitute part of the written agreement. So the court rejected the defendant's contentions, holding that oral evidence could not be led to contradict the terms of the written document. An appeal was dismissed. So this is a case concerning the parole evidence as we have it in Ghana applicable. Oral evidence may, however, be admitted to explain the circumstances and terms of a document. It cannot be ruled out totally. It's helpful, it can be used. It also is used to explain unclear and ambiguous evidence or statements made by another person in the course of the agreement or disagreement, or even in the contractual document. It will help really clarify a lot of things. Unless this rule will not be really attainable where it is illegal or induces another person by fraud. So formation of a contract. How do we form a contract? The general requirements for the formation of not just a contract but a valid contract include the following. For a contract to be regarded as valid, an agreement to be regarded as valid and could be binding on parties, then certain elements must be considered. The first is an offer. There must be an offer. Without offer, you cannot accept. And there must be an acceptance. And that acceptance must not be qualified, unqualified acceptance. You accept the terms and conditions from the offerer. Then we have what we call the consensus ad idem. Consensus ad idem. Ideas of the parties must be the same, not one thinking of something else, the other thinking of another thing. But they must all be in their mind an object over which they are contracting. So there is a consensus ad idem. Valuable consideration, otherwise under seal. So a contract that is not under seal, written and sealed, then there must be a consideration. We have to look at what constitutes a consideration. Promises must have a consideration, else they will not be binding. Or else we refer to such promises as gratuitous. So there must be always something you give in for as a consideration. Genuineness of the consent. Your consent to an agreement must be genuine, must be real, not artificial. The contractual capacity of parties. Another requirement for a valid contract is the parties must have capacity. When we talk about capacity, we will look at infants, minors, or infants or children, whether they have a capacity to enter into a contract, somebody who is drunk, a drunkard, or insane person who is not conscious, insane, mad. All these are concerning capacity of the parties. Then we also talk about intention to create legal relations. There must be intention between the parties that they are ready to enter into a contract that will be binding upon them, a contract that will have a binding force. Then legality of the objects. For a valid contract, the object over which the parties are contracting must be really legal, not illegal. There must not be something against which the law has been written or provided. So it must be legal, not illegal, not against the criminal acts of Ghana or prohibited objects, but must be what is allowed by law. Then possibility of performance. The parties must be reasonably able to perform on the contract. So all these I've listed here like 9 points concerning validity of a contract. When they are absent or they are not adequate, then we have either to declare them or regard them as void or voidable or unenforceable. So all these points I've listed, when they cannot be accepted as valid contract, we can declare the documents or the action as void, or they are voidable, or they are unenforceable. We have to understand these three effects of an agreement. There are legal effects of an agreement. We can declare the agreement as void